Good afternoon. This is Heather Van Wild with Raindrop Works. I was given a heads up about a order that had come out. I believe this would have been, filed on the 27th. Today's 27th. Okay, so this was just filed today in Oregon Federal Court, and there was a call out for legal Twitter if somebody could poke through this. I'm not a lawyer, obviously, but I'm at least familiar enough to be able to poke through things, and I said I'd go ahead and take a look. And yeah, I wanted to go ahead and give a bit of an update here. The particular case that we're looking at is Pettibone versus Biden. This was originally Pettibone v. Trump, but as we will go into later on, when there is the change in presidents or official positions, the courts will generally transfer the case to whoever is now heading it up. So when Donald Trump left office January 20th, Joe Biden took over. He takes on the responsibility of the official capacity in a whole slew of lawsuits. Those who aren't familiar with this particular case, it is the overarching part of it is about alleged illegal activities that took place by federal officers during the George Floyd protests. One of the headlining incidences that this case talks about is the now infamous snatch vans, where we had unmarked SUVs coming up and unmarked or unnamed people in camo gear were just grabbing people off the street, which caused national outcry. This also does go beyond that into the general abuses of power that came from the Federal Protective Services, U.S. Marshal Service, and all of those going into things. Now, this opinion order, this is not saying that the entire case is decided. This is going into basically looking to dismiss parts of the case, and some of it was done, some of it was denied, most of it is continuing on. And I'm going to go ahead and try to reference this with the actual complaint that was filed, and a little bit of other information to give more context as we go. So again, this was filed today, December 27th. Judge Simon is the district judge for the Federal District Court of Oregon, and he is overseeing a number of other cases. Two of the more prominent ones are the Department of Justice settlement agreement with the City of Portland, where Portland police have been under a consent decree for a number of years now for, among other things, their maltreatment of people in mental health distress instead of treating them like people they're more likely to be shot. Another of the larger cases is the Index News versus City of Portland, and that case also ended up coming in under being filed against federal forces as well. This was dealing with journalists and legal observers that were being targeted by first Portland police and then also federal officers, which is part of why I was paying a little more attention to that one, since when I was on the ground it was directly affecting me. So yeah, Judge Simon has been fairly steeped in the issues that we have with law enforcement in the Portland area. Some of the stuff that was going on was sent to a magistrate judge, Yoli Yim Yu. It may be Yao. I don't have a pronunciation, and if I get it wrong, I deeply apologize in advance. Text does not give pronunciation context. Basically, there were lesser hearings that were done in front of a magistrate instead of the judge, who will then come up with recommendations that he gives to the judge, and then the judge reviews them and says, whether yes or no. The judge recommended the court grant the motion to dismiss filed by defendants Chad Wolfe, who was the former acting secretary of the Department of Homeland Security, and Gabriel Russell, who was in charge of Federal Protective Services for Region 10, which includes the Portland area. Basically, the idea is that Mr. Russell was the person who was in charge of protecting federal buildings in the Portland area during the George Floyd protests, and Chad Wolfe was with significant court precedents leaning towards the idea that he was in his position and making decisions unconstitutionally, but he was nominally at the head of Homeland Security at the time. And I am just now realizing that I need to tweak the zoom on this. There, that's better. So what this is going into is not to dismiss the case, but to dismiss these individuals from the case. He also recommended the court dismissing the 1st, 7th, and 8th claims that were associated against these two defendants in their individual capacities. Now, we'll go ahead and take a peek at the complaint and those claims themselves, but they were being sued in both individual and personal capacities. This does, at the end of the day, remove Chad Wolfe from the case, as we will see. In fact, I can go ahead and just a second. Yeah, there is a lot of redactions in. This is the second amended complaint that was filed, which I've gone ahead and kind of skimmed through and made some markings. There's a lot of redactions here. These are all individual officers, it appears, that were identified as part of the lawsuit in this case. Yep, here we go. So yeah, like I said, originally it was Donald Trump was the one that was sued as his official capacity, but there is a federal rule that when there was a change in administration, the person who is the party in that has changed. So now it is President Biden. Chad Wolfe, when he was removed later, Secretary Alejandro Mayorkas is now the person who is being sued in the official capacity as the head of DHS. From my understanding, Mr. Russell is still the regional director for Region 10, so he is still here in the official capacity. So yeah, as we go in, the court did adopt in part the findings and dismiss the first claim against defendant Wolfe, which would have been in his personal capacity at this point because the official capacity has been transferred to someone else, and the 7th and 8th claims against Wolfe and Russell in their individual capacities. And again, we'll go a little bit deeper into that once we have a little more background to this. Court also denies Russell's motion to dismiss the first claim against him. We go into the Federal Magistrates Act, basically talking about how the court can send things to a magistrate. Magistrate holds a hearing, makes recommendations, and the judge can use that and, do whatever they feel is appropriate with it. This goes on to talk about that appears Judge Simon, even the parts of the recommendations that weren't contested by either party, the judge still looked over just to make sure there weren't any huge glaring errors. And again, this all rolls back to a motion to dismiss, which the court confirms is for failure to state a claim may be granted only when there is no cognizable legal theory to support the claim, or when the complaint lacks sufficient factual allegations to state a facially plausible claim for relief. Now, we'll see some of this in other court cases I'm planning on having talks about later, about how you can't really just sue someone just because. You have to come to them with, this is the allegation, it makes sense that this could have happened, and this is the legal basis supporting my suit. So, again, a complaint must contain sufficient factual allegations to plausibly suggest an entitlement to relief. You need to be able to make a claim that seems like it could succeed at a jury trial. Such as not unfair to require the opposing party to be subject to the expense of discovery and continued litigation. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for misconduct alleged. And in this case, we are talking about a broad swath of civil rights violations that have been alleged against the federal government, including unlawful detainment, the excessive use of tear gas and riot munitions, the misuse of such things. If you look at the actual complaint, there are pictures in there of injuries that were sustained by plaintiffs in the case, and some of them are pretty gruesome. Another one that is not in this case because it's a separate case is a reference to Donovan Labella, who was shot in the head with a less lethal munition while he was holding a speaker above his head. It has caused severe damage, lifelong impairment, and that is a completely separate case that has been stymied because the federal government does not want to admit to who was deployed there that night to figure out who it was that shot. So anyway, going back to this, the plaintiff filed objections to the magistrate's recommendations. Mr. Wolfe, Mr. Russell responded. Basically, what started was the plaintiffs arguing that the findings and recommendations erred in recommending dismissal for the first claim as an improper extension of Bivens. Now, Bivens is kind of a complex situation, and I went ahead and tried to get some information here where It's a lawsuit for damages when a federal officer is acting in color, which is basically illegally. They're showing their badge, but they're doing things that they're not allowed to do while making it seem like they are allowed to. And acting in that authority violates the Constitution by federal officers, where the plaintiff has to prove that constitutionally protected right has been violated, and a lot of these are going to be Fourth Amendment, First Amendment violations, things like that. This came from a 1971 case where the Supreme Court held that a violation of one's Fourth Amendment rights by federal officers can give rise to a cause of action for damages for unlawful search and seizures. The Bivens case itself is basically, here we go. Petitioner's complaint alleged that the respondent agents of the Federal Bureau of Narcotics, acting under color of federal authority, made a warrantless entry of his apartment, searched the apartment, and arrested him on narcotics charges. All the acts were alleged to have been done without probable cause. They had no proof or reasonable suspicion that there was narcotics there. They just went into this random guy's house. Originally, it was dismissed because it failed to state a federal cause of action, and because these were federal officers, they had essentially qualified immunity. Court of Appeals upheld part of that, and it went to the Supreme Court, who ended up saying that no, this was not the case here. So this gives a framework which federal courts have in recent years been loath to try to expand on. They have a feeling or a belief that this is something that needs to be addressed through the legislature, which they are right. Much like any of the other police accountability measures that have been pushed for and questions of qualified immunity, there are definitely things that need to be taken care of at a legislative level that are not for various generally political reasons. So we have that, and there will be further discussion on the improper extension section here. Plaintiffs also argued that defendants Wolfe and Russell are not entitled to qualified immunity, which was something that the magistrate judge did not address, and plaintiffs additionally contend findings and recommendations erred by concluding that plaintiffs had not adequately alleged an agreement between Wolfe and Russell and Portland Police to deprive plaintiffs of their civil rights sufficient to support a claim, as well as plaintiffs argued the judge erred by not granting plaintiffs leave to amend. So the first thing that I go into is the Bivens claim. Supreme Court has made clear that expanding Bivens remedy is now a disfavored judicial activity. Basically saying that to try to expand it further is a significant step, breaking apart separation of powers between the judicial and the legislative bodies. Congress is the one who should be the one to determine what liabilities, punishments, monetary fees should be imposed upon individual officers and employees of the federal government. And as such, the Supreme Court has consistently refused to extend Bivens liability to any new context or new category of defendants for the past 30 years. Now, I think this 30 years is referencing 2001, so that would be, if I'm reading this right, that would be back when Bivens was first decided, which was 1971. Supreme Court precedents now make clear a Bivens remedy will not be available if there are special factors counseling hesitation in the absence of affirmative action by Congress. So now there is a higher standard that the courts will use when figuring out if something could qualify under Bivens as a two-step inquiry. The first thing is figuring out if there's a new context or a new set of defendants. And the second is figuring out whether there are any special factors that counsel hesitation about granting the extension. Wolfe and Russell both argued that allowing claims against them would be extending claims to a new context and new category of defendants, and the special factors counsel against extending Bivens. So, okay, cool, thanks. I see we had a raid here. Just a bunch of people showing up. Basically, this is probably boring for most people, but going over a recent order that was sent down in federal court in a fairly significant police brutality federal civil rights abuse lawsuit that's going on right now in federal court in Oregon. So, on that first prong of the new Bivens, plaintiffs disagreed with Judge Yo's new context analysis, saying that the findings and recommendations made a large-scale operations exception. Basically saying that because this was like a task force kind of thing, they're immune from Bivens claims. But the plaintiffs say their claims are regular Fourth Amendment claims for illegal search, seizure, excessive force, and are appropriate, referencing another case in 2018. The court did not read the findings and recommendations as concluding that plaintiff's claim presents a new context for purposes simply because of the large-scale operation. The judge referred to the scope of the operation, but did so in describing the difference between line-level agents in Bivens, again, the narcotics agents that actually busted in the door and searched the apartment, and the high-level positions and non-direct roles held by defendants Wolfe and Russell in this case. Above the law, yes and no. As we'll find out, I mean, a lot of this is dealing with the people in their individual capacities. There is actually, in the idea of holding the government responsible for the actions of its employees, there is still a lot to be decided on with this. But the court did agree with the judge, however, that the plaintiffs seek to create supervisory and general agency liability under Bivens for the Wolfe, and that is a new context. Reliance on another case is unavailing as to defendant Wolfe, because in the other case they reference, Circuit Court concluded plaintiff's claim was similar to Bivens and therefore does not present a new context. This was another case where apparently a federal agent had personally performed a search. And at the time, the Ninth Circuit said there's no difference between Iane and Bivens with respect to the rank of the officers involved. Oh, thank you. So both Bivens and the second case that the plaintiffs referenced were both line officers that were directly doing the alleged interference with civil rights. When they're talking about former acting director Wolfe, he was way up at the top of the food chain in Washington and didn't have supervisory of, he wasn't, or at least we have no evidence that he was watching or directing any of the law enforcement activities generally at the Portland courthouse during the protests against federal officers. The plaintiffs did allege that defendant Wolfe established high-level policy at DHS, generally was involved in sending a large federal response to Portland, made statements to the press and on Twitter, and held one meeting in Portland with the police union president and several officers of the police department. These allegations are insufficient to show direct conduct in the alleged misconduct, but simply seek to impose liability for high-level agency supervisory conduct, which would be new context under Bivens. And that's why Chad Wolfe is going to be able to sneak out of this lawsuit, because he was far enough away that he manages to avoid personal liability. In his position as Director of Homeland Security at the time, not so much, but like we said in the beginning, because there's been a change in administration, that party gets changed to the replacement for him. Circling back, though, to the allegations against defendant Russell, who is the director of the Regional Federal Protective Services for this area, those are different. He commanded Operation Diligent Valor, which was the expanded federal response to the protests in Portland. They allege he was personally in Portland and present in the command center during much of the alleged misconduct. They allege that he had tactical control of the operations during the relevant period, and the federal officers engaged in the misconduct were in his chain of command, and that he knew the federal officers were engaged in using excessive force, making illegal arrests, and he personally watched by video from the command center and on social media the officers' alleged misconduct, that at least from July 12th through the 29th, so over 2 weeks, he personally observed protesters and the responses by federal officers, that he was aware of the use of force, and he was specifically aware of the use of force by federal officers against Christopher David, who was the Navy vet who kind of made national media for standing up in front of the federal officers, asking them why they were not adhering to their oaths to the Constitution, and got beat and maced in the face while he wasn't being aggressive or, I guess, possibly intimidating, because he's a stocky, tall, stocky guy. He's got a presence if he wants to, but that's not enough reason for somebody to be beat by federal officers. So again, the judge is laying out, this was not some guy watching from Washington reading news reports and stuff. No, this was the guy who was directly supervising the line officers. Plaintiffs also allege that defendant Russell directed or was aware of the arrest of persons without probable cause, including Pettibone, which I believe Pettibone was the one of the ones that got pulled into the snatch van at the time. Further allege that despite Russell's personal knowledge of the alleged excessive force and unlawful arrests, he did not change tactics, did not discipline officers, did not speak out against the misconduct, did not take any steps to stop the unlawful conduct. Therefore, the plaintiffs believe that Russell, directed, facilitated, condoned, ratified, or is otherwise properly held responsible for the misconduct. Basically, we're going back to Bivens again, where in Bivens' case, we had those narcotics officers breaking into the guy's apartment and searching it. This would be like if their shift supervisor came with them and just leaned against a wall while he watched them tear the place apart without probable cause. So they contend the mere fact that Russell held a supervisory role does not present a new context or new type of defendant for Bivens purposes. For this argument, plaintiffs rely on Carlson. another case where the plaintiff, a prisoner, or the mother of a prisoner who died in custody, and the administratrix of her son's estate sued the director of Federal Bureau of Prisons, Assistant Surgeon General of the U.S., and the chief medical officer of the prison in which the prisoner died, among others. District Court had previously dismissed the director of Bureau of Prisons and the Assistant Surgeon General for lack of service, and then dismissed the complaint for lack of subject matter jurisdiction. Basically, cutting out the case at the knees and then saying, well, you don't have enough of a case now. It was appealed, and the Seventh Circuit reversed it, saying that they had been served and that the plaintiff did have a remedy against the defendants. So, looking at the Carlson case here, the Supreme Court did not parse the defendants against whom the plaintiff could pursue her cause of action. They characterized the petitioners as federal prison officials and then described the allegations. Respondent alleged that petitioners, being fully appraised of the gross inadequacies and of the seriousness of the medical condition, nonetheless kept him in that facility against the advice of doctors, didn't give him competent medical attention, gave inappropriate drugs, which made the asthma attack worse, tried to use a known broken respirator, which made things even worse. And then this was a systemic issue where it wasn't just the medical staff that were directly working on him. They could prove that it was up the chain. These problems were known and failed to be addressed. It did not appear that the Supreme Court considered the Assistant Surgeon General and Director of Bureau of Prisons to be persons fully apprised of the gross inadequacies, but the Supreme Court did not expressly discuss that question. Let's see here. So that basically, skim through the rest of the Carlson stuff, it does muddy things a little bit. But again, it goes back to the idea that the people at the very top of the federal agency are not going to know the minutiae of administrative decisions. They have more of an operational control where the goal is, protect this building. And the lower level people are going to figure out how to protect it. Yeah, buck stops elsewhere is a way to, and we see this in a lot of other like white collar crimes as well. Is where you try to have so many people be involved with a decision that you can't pin down this person gave the illegal instruction. And that's part of why you see these big corporations that are paying fines instead of people actually getting charged for their actions. Going on again, a plaintiff can bring claim under Fourth Amendment for illegal search and seizure and excessive force. Ninth Circuit, which is the circuit that Oregon is part of, has described the necessary allegations for supervisor liability. And in this particular case, we hold that taking qualified immunity into account, a supervisor faces liability only where it would be clear to a reasonable supervisor that his conduct was unlawful in the situation he confronted. And a plaintiff can establish that affirmative link by alleging the supervisor was a primary violator or direct participant in the rights-violating incident, or that a responsible official supervises, trains, or hires a subordinate with deliberate indifference toward the possibility that deficient performance of the task may contribute to a civil rights deprivation. Which, again, he was watching the footage, he knew what was going on for at least a 2-week period in the middle of things. In the 1983 context, which Code 1983, I believe, is part of the Civil Rights Act, in which vicarious liability is not imposed, Ninth Circuit has explained that for a supervisor to be liable, the supervisor must be personally involved in the constitutional deprivation, or there must be a sufficient causal connection between the supervisor's alleged wrongful conduct and the constitutional violation. And that's where they're going to hit things on this. This causal connection can be established by setting in motion a series of acts by others, or by knowingly refusing to terminate a series of acts by others, which the supervisor knew or reasonably should have known would cause others to inflict a constitutional injury, which is what a lot of this case has been about. The frontline federal agents inflicted constitutional injury. He was watching it on the video. He refused to do anything. Going on to reference a case where Ninth Circuit explained a court should not accept wholly conclusory allegations, that a supervisor reviewed and approved operation plans as sufficient to show that the plans resulted in unconstitutional conduct. Ninth Circuit also held an allegation that a supervisor had direct control over line agents who committed constitutional violations was insufficient in the absence of additional allegations plausibly showing the supervisor had reason to know that, in this particular reference case, Border Patrol agents who presumably conduct numerous stops had frequently stopped plaintiffs, much less than they did so with reasonable suspicion. That sounds like a profiling charge. Ninth Circuit stated in this other case that they did not have factual basis for imputing any such knowledge to the defendants. Here, plaintiffs allege more than wholly conclusory allegations that Russell reviewed and approved the operations plans. They say that he watched from the command center the violations as they were happening. He also monitored social media video posts and watched the violations. He had specific knowledge of the conduct against Christopher David and Mark Pettibone, which are two of the plaintiffs in this case. He directed or ordered some of the alleged conduct, including some of the unlawful arrests. He was in Portland from at least July 12th through July 29th. They show that he was more directly involved in the alleged misconduct than the chief medical officer in the Carlson case or the supervisory defendants in the Chavez case. So plaintiffs have alleged facts that plausibly show a stronger case for him to be individually sued on this. At this stage of litigation, accepting plaintiffs' well-pleaded allegations are true because this hasn't gone to a trial yet. So at these earlier stages, they assume statements to the benefit of the plaintiff until they can actually be adjudicated in front of a jury. So, as the court must, plaintiffs have alleged facts showing direct personal conduct by Russell that are sufficient to state a claim under Bivens. Those are his personal actions. And then they go on and reference a whole lot of other previous cases. Plaintiffs' claim about defendant Russell also do not simply focus on high-level decisions, unlike their claims against Wolfe, and the claims that were the focus of Supreme Court analysis in an Abbasi case. Instead, plaintiffs' claims against Russell largely focus on his personal conduct. Additionally, his rank is not meaningfully different from the rank of the defendants in Carlson against whom the claims are stated. Further, although the individual capacity defendants, which would be Wolfe and Russell, try to distinguish this case based on the fact that the conduct took place in public instead of inside a home, courts have regularly applied Bivens to Fourth Amendment cases that arise in public. So they tried to say, well, we didn't, because we didn't break into someone's house, it's not, it's a new context, but Fourth Amendment violation is Fourth Amendment violation. It doesn't matter so much if you're inside your home or if you're walking down the street. It's, it's still an unlawful search and seizure that they have to worry about. And there is actually other cases here. Bueno Diaz versus Mercutio. Yeah, coast to coast, the Constitution is supposed to apply. So we have the Southern District of New York case. Says, last, the court rejects defendant's argument the location of the arrest in public rather than in his house constitutes a meaningful difference from Bivens. So that's exactly the circumstances that we're seeing here. Referencing a whole bunch of other cases. Then go into the special factors. With the claims against defendant Wolfe, the court agrees with Judge Yo that several of the special factors the Supreme Court identified counsel against extending Bivens to the types of claims alleged. Of particular concern are separation of power principles to permeate plaintiff's allegations. Arguing that the plaintiff's operative complaint alleges that defendant Wolfe was acting pursuant to an executive policy or some other high-level policy. The plaintiff said that references plaintiffs contend that references in the complaint to the executive order and to the term policy did not intend to allege that defendant Wolfe's actions were pursuant to a policy. That one honestly confuses me. Basically, President Trump put out an executive order saying we have to protect federal installations and monuments and stuff, and Chad Wolfe then put out policy memos and gave orders that aligned with that executive order. And it almost seems, the way that I'm reading this, that the plaintiffs are both trying to say that he was following executive order but also was acting on his own, and I don't quite follow the logic to that. Plaintiffs ask for leave to amend to remove such references if the court were to find the references suggest the plaintiff's claims are based on executive policy. The objections are unavailing. And I think this goes back, one of the arguments that the plaintiffs brought up contesting the magistrate's recommendations was that they weren't given the chance to amend their claims. And Judge Simon says these objections are unavailing. Whatever label plaintiffs try to put on their claims against defendant Wolfe, no matter if plaintiffs use the word policy in their allegations, it is evident from the substance of the claims that the claims are based on allegations that defendant Wolfe created and had others implement a high-level policy the plaintiffs allege resulted in the unlawful conduct by line-level officers. But again, we still have that separation from high-level policy and what happened on the street for a Bivens claim. And based on the centrality of separation of powers concerns in the Bivens special factors analysis, courts must consider the risk of interfering with the authority of the other branches. Again, the Supreme Court is really wanting the legislative branch to address this. For as much as we see them expanding their power in other things, Bivens cases seems to be one thing they're very hesitant to do. Judge Yu correctly recognized the Supreme Court's repeated admonition that a Bivens action is not a proper vehicle for altering an entity's policy. and that the allegations center on Defendant Wolfe as a high-level official acting under a high-level policy, and this creates significant separation of powers concerns. The claims also risk an uninvited intrusion into executive branch policymaking and operations, so this is also concern of separation between judicial and executive branch. And risk inobtrusive discovery of a former high-ranking cabinet-level official. So as a result, the court adopts Judge Yo's analysis as applied to Defendant Wolfe, and because the court dismissed the claims against Wolfe, they did not need to address his qualified immunity argument, where there was basically a claim that because of his position, he's got broad immunity against individual suit. So that's where we sit with Defendant Wolfe, and as we get towards the end of it, we'll go ahead and get a fuller idea of what that means going forward. So then we go on to Defendant Russell. Assuming arguendo, basically for argument's sake, that the claims against Defendant Russell arose in a new context, the court still would find a Bivens remedy appropriate based on the special factors analysis, his connection and direct observation. The individual capacity defendants argue as special factors those that relate to Defendant Wolfe, that the claims challenge a high-level policy and the claims against cabinet-level officials risk discovery into communications with the former president. Those concerns are not applicable to the Fourth Amendment claim the court finds sufficiently stated against Defendant Russell. They don't have to worry about communications between Wolfe and Trump because we're focused on what Russell did with the line officers. The claims focused on his personal involvement and direct causal connection to the constitutional violations while he was in Portland, specifically observing federal officers while he was in the command center, directing federal officers, and setting in motion and failing to stop the constitutional violations he observed. It's not based on his purported high-level policy decisions or communications with President Trump. They also argue the availability of other remedies, such as injunctive relief, Federal Tort Claims Act, and the fact that there is a process under which an inspector general can review alleged misconduct gives alternatives to prevent plaintiffs from using Bivens liability for a Fourth Amendment claim. Basically claiming that where there exists any alternative existing process for protecting a plaintiff's interest, then a court should refrain from providing a new and freestanding remedy of damages. The alternative remedy, however, must provide adequate protection. Both Supreme Court and Ninth Circuit have held the FTCA is not an adequate alternative remedy to preclude a Bivens claim, and the court is bound by that precedent. Court also does not find that Inspector General's post hoc or after-action review of potential excessive force and unlawful arrest by federal officers, in which the Inspector General considers the agency's conduct and reports to Congress, is an adequate remedy. Finally, injunctive and declaratory relief is not an adequate remedy for the harm caused by the completed acts against plaintiffs, rather than preventing future harm. And here it references another case, Bull. Finally, injunctive relief is an inadequate remedy, for Bull is seeking damages for Agent Egbert's completed actions rather than protection against some future act, which is something you usually see with injunctive and declaratory relief, is an order saying you will no longer do this thing. Well, obviously the thing has already been done. So, saying don't unlawfully arrest people in the future does nothing about the fact that you unlawfully arrested people before. Going on now, we take a look at qualified immunity, and I believe this is going to be focused on Russell again. The doctrine of qualified immunity protects government officials from liability for civil damages. Yeah, that's... Qualified immunity has its own... I want to say issues, but that's doing enough heavy lifting there for a world-class weightlifter. So the idea of qualified immunity balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. Whether qualified immunity can be invoked turns on the objective legal reasonableness of the official's acts, and reasonableness of official action in turn must be assessed in light of the legal rules that were clearly established at the time the action was taken. The privilege is an immunity from suit rather than a mere defense of liability. It is effectively lost if a case is erroneously permitted to go to trial. And for this reason, the Supreme Court has stressed the importance of resolving immunity questions at the earliest possible stage in litigation. Basically, if they can prove that Russell had qualified immunity, then at this stage they would have to remove him from being sued in his personal capacity. He could still be theoretically part of a suit in his official capacity, but that would be the government being on the hook for his actions instead of he himself. Qualified immunity, however, is only an immunity from suit for damages. It is not an immunity from suit for declaratory or injunctive relief. Supreme Court outlined a two-step process for determining the applicability of the qualified immunity doctrine. First step is to determine if a constitutional right would have been violated on the facts alleged, and the second step is whether the right was clearly established. Whether the right was clearly established is from pretty much all of the examples that I've seen of qualified immunity. That second step is where things run into problems, where people will say, well, we didn't have previous, it wasn't previously said that this specific action was something that somebody had a right to. And courts have been hesitant to expand when rights were clearly established. The constitutional issue, however, need not be addressed first in every case. Regardless of whether the violation occurred, the officer should prevail if the right asserted by the plaintiff was not clearly established, or the officer had reasonably believed that his particular conduct was lawful. To determine whether a government's official conduct clearly violates established law, a court has to ask if it would have been clear to a reasonable officer that the alleged conduct was unlawful in the situation he confronted. It is not necessary that the very action in question has previously been held unlawful. That is, an officer might lose qualified immunity even if there is no reported case directly on point. I like seeing that. I think we need to see that more often. Courts seem to like to ignore that. But in light of pre-existing law, the unlawfulness of the officer's conduct must be apparent. The clearly established requirement operates to ensure that before they are subject to suit, they're on notice that their conduct is unlawful. Thus, the key inquiry in determining whether an officer has qualified immunity is whether the officer had fair warning that his conduct was unconstitutional. Yeah, he was in town for over 2 weeks here. The plaintiff bears the burden of making and showing that the right was clearly established at the time of the alleged violations. When considering whether qualified immunity applies, the court must resolve all factual disputes in favor of the parties asserting the injury. Defendant Russell raises two primary arguments for why he's entitled to qualified immunity. First is he's entitled because he did not personally participate in any of the violations. And he, to support that, he says the plaintiffs offer no more than conclusory allegations that he approved or directed the alleged conduct, or that the officers were in his chain of command. The court rejects that argument for the reasons discussed above. It was more than just he was their supervisor. He was watching this as it happened. His second argument is that plaintiffs failed to allege any clearly established violation of the Fourth Amendment. He argues that using a balanced test established in Graham v. Connor, that plaintiffs failed to allege a Fourth Amendment violation at the first step of the qualified immunity analysis, and that Russell argues the second step of the analysis, no clearly established law provides that the force used in the context of protest, crime control, and protection of federal property was unlawful, or that he may be held liable for such conduct. I don't like the way that sounds, but Judge Simon will go into this more. Starting off with the Fourth Amendment violation, Russell argues the government interest in policing large protests outweighs plaintiffs' interests, and thus plaintiffs failed to allege a Fourth Amendment violation under Graham. He asserts a reasonable officer could have believed that using, quote, significant force to control large crowds of protest to prevent, quote, bad actors from using the crowd as cover to endanger the officers was lawful. As someone who has been witness to that significant force being used against large crowds, instead of focusing on the bad actors, that is... Yeah.
Bruh.
Anyway, plaintiffs, however, do not allege that federal officers generally responded with too much force to large protest crowds. Instead, the plaintiffs allege specific incidences, including that federal officers snatched Plaintiff Pettibone, a U.S. citizen, from a public city street, allegedly blocks away from the federal courthouse, took him to the federal courthouse, searched him, detained him, then released him, all allegedly without a warrant and without probable cause. Yeah, that had nothing to do with the crowd. Took a photograph of plaintiff's Max Smith while he was wearing clothing designated as press, and while he was attempting to interview federal officers, and several hours later shot him in the head with an impact munition without warning or a dispersal order while he was standing alone away from the courthouse and from other protesters. Again, no large crowd there. Shot plaintiff Miller in the head with a tear gas canister without warning or dispersal order, causing a concussion and cut requiring several stitches, while he was standing several blocks away amidst a group of peaceful protesters. No indication of bad actors. Shot plaintiff Dennison in the head with a tear gas canister without warning or dispersal, standing with her arms linked in the wall of moms near the fence around the federal courthouse, peacefully protesting. Shot plaintiff Healy in the head with an impact munition when with a group of peaceful protesters a block away from the courthouse, causing a concussion. Shoved, repeatedly struck with batons, sprayed chemical irritant in the face of plaintiff David in response to him asking federal officers why they were not upholding the Constitution. Breaking his hand and requiring him to have surgery. Shot a chemical irritant point blank in the face of and struck with batons, including in the face of plaintiff Obermeyer without warning. When he repeated Mr. David's question about whether the federal officers knew their oath of office to uphold the Constitution. Shot plaintiff McNulty multiple times without warning or dispersal order with tear gas, rubber bullets, pepper ball, one of which went through the clothes, skin, fat layer, and into the muscle, requiring him to go to the emergency room while he was standing with a group of peaceful protesters on a city street a block away from the federal courthouse. All of these during the time that Russell is alleged to have been in Portland and at the command center directing and observing the conduct of federal officers. So, yeah, it was not, I'm at home getting reports. He's right there watching it real time, and almost all of these were groups where there was no threat coming from at all, and everything that we saw suggested that it was retaliatory, which is something that should be, you should not be able to get qualified immunity for attacking people in a retaliatory manner and causing injuries and snatching them off the street, things like that. Here it looks like Judge Simon then goes on to talk about the individual plaintiff's allegations. Russell does not assert any argument for how Pettibone fails to allege a violation. Arresting someone without a warrant or probable cause is clearly a Fourth Amendment violation. Plaintiffs David and Obermeyer, not incidents of crowd control, but targeted and specific uses of force in response to verbal questions. To determine whether an officer has violated Fourth Amendment, court balances the nature and quality of the intrusion on the individual's Fourth Amendment interests against the countervailing government interests at stake. Court assesses the gravity of the intrusion, then assesses the importance of the government interests, and finally balances the gravity of the intrusion on the interests against government's need for that intrusion to determine whether it was reasonable. For the first step, both pepper spray and baton blows are blows of force capable of inflicting significant pain and causing serious injury. As such, both are regarded as intermediate force that, while less severe than deadly force, nonetheless present a significant intrusion upon an individual's liberty interests. Less than deadly force may lead to serious injury, may be used only when a strong governmental interest warrants its use. Thus, alleged conduct resulted in serious intrusion. Second step in analysis, the interest by assessing the core factors, the severity of the crime, whether the suspect posed an immediate threat to the officers or public safety, and whether the suspect was actively resisting arrest or attempting to evade arrest by flight. Factors are not exclusive, and the court looks at the totality of the circumstances. Ninth Circuit has stated, however, that the most important single element of the three factors is whether the suspect posed an immediate threat to the safety of the officers or others. I bet we're going to find that they did not. Of the three factors we traditionally examine in determining government interest, the most important is whether the individual posed an immediate threat. Based on plaintiff's well-pleaded allegations, which, as noted, the court must accept at this stage of litigation, David and Obermeyer were not committing any crime because there was no dispersal order given with which they failed to comply, and they were merely asking federal officers why those officers were disregarding their constitutional oath. Even if they had criticized the officers in that exchange, such criticism would not have been a crime. And they reference United States v. Puccia. Puccia used profanity to express his disapproval of an officer's conduct. Criticism of the police, profane or otherwise, is not a crime. Some people might say it's in bad taste, but that is not a crime. No indication plaintiffs were violent or otherwise presented a threat. No reason to conclude plaintiffs were resisting or evading arrest, although they did attempt to block the baton blows. Russell identifies no other factor that supports the government position other than generally arguing the officers could use force to, quote, seize large crowds and to prevent, quote, bad actors from using the crowd as cover. That interest, assuming it were viable, is unrelated to the conduct pertaining to David and Obermeyer, who were not part of a large crowd or subject to force while officers were attempting to quell large crowds. Instead, they were specifically targeted and individually engaged, possibly in retaliation for their questions to officers. Thus, the government has not shown at this stage of the lawsuit, based on the allegations, that the government had a strong interest in engaging in the alleged conduct. Balancing the intrusion against Fourth Amendment interests with the government's need for that intrusion weighs in favor of the plaintiffs. use of intermediate force requires a strong governmental interest, and the individual capacity defendants have failed to show that interest at this stage. The government interest is insubstantial, and the intrusion is significant. The Graham analysis supports the use of force was not reasonable. Now that is at this stage. As it goes into trial, that could change. From everything I'd seen, they're gonna have their work cut out for them to try to argue that. The remaining named plaintiffs all allege they were shot in the head with less lethal impact munitions. They all allege they were shot without warning, without being given dispersal order. They were all among peaceful protesters staying away from other protesters. As alleged, none were among the violent or bad actors. Like batons, impact munitions are intermediate force, requires a strong countervailing government interest. Use of such force should be preceded by a warning when feasible. Referencing one of the other cases, I think this is Delore here. The absence of a warning or an order to halt is also a factor that influences our decision. Our cases demonstrate that officers provide warnings when feasible, even when the force used is less than deadly. All the remaining plaintiffs allege they were not given any warning before being shot. Yeah, it singled out and punished definitely does. It gives that very strong impression. Yeah, and I'm right now thinking back. There was a night I was out covering kind of a vigil protest, and it was one of the nights when Joanne Hardesty was out speaking, and I remember I was delayed on getting out of the area afterwards, and all of a sudden we had FSP people coming out of the, I think it's the IRS building on the other side of the Justice Center, and the only thing that was going on was, like, there were fences around the parks that people were taking down. And I really can't think of any warnings of munitions being used before the whole area was blanketed in gas. Yeah, impact munition being only intermediate, I think because they're saying it's not using lethal force, it's the less than lethal force. I'm not sure what they would say is below intermediate. Maybe that's unarmed, grabs or something. I'm not entirely sure where they delineate stuff, but it does seem like intermediate is definitely significant, but not as badly as lethal force. And you are bringing up a good point, though, with the state monopoly on violence. If one of us used a tear gas canister on one of their houses, they'd call that a terrorist act. But I don't know that personally. I mean, I know Donovan Labella got his head caved in with a less lethal munition. There is a journalist that I follow who was out in out where in the area where George Floyd died, where the protests first took off. Lost her eye by getting shot with a less lethal munition while she was trying to take photos. We've had lots of significant injuries, and there's a reason why they're not supposed to be aimed, above midsection level. It's even if you're fully healthy, those can cause serious injury and death if you're not careful. Have someone like me who is more prone to injuries from impacts, that gets even worse. Individual capacity defendants make the same argument. Government has an interest in general law enforcement. Large crowd control and stopping riotous people and bad actors in the crowd, and can therefore use force against the entire crowd. The Ninth Circuit, which again is the circuit court that covers Oregon and a bunch of other states, however, has instructed the government to use a different approach, explaining demonstrations can be expected when the government acts in highly controversial ways or other events occur that excite or arouse the passions of the citizenry. The more controversial the occurrence, the more likely people are to demonstrate. Some of these demonstrations may become violent. The courts have held the proper response to potential and actual violence is for the government to ensure an adequate police presence and to arrest those who actually engage in such conduct rather than suppress legitimate First Amendment conduct as a prophylactic measure. Obviously, there's going to be questions about adequate police presence at an anti-police protest, but still, in the most charitable light for the government, they're only supposed to target those who are actually doing crimes, not let's just target everyone that we don't like. Only when the crowd is behaving as a unit and it is not possible for the police to tell who is armed and dangerous or engaging in criminal acts and who is not, may law enforcement have reasonable suspicions as to the members of the entire group. And we're referencing cases here from 96 and 2015, so it's not like this was stuff that just came out last week. Based on plaintiff's allegations, this was not the case with respect to the remaining plaintiffs when they were shot. At this stage, court accepts the allegations as true, construes in the light most favorable to plaintiffs, and draws all reasonable inferences in plaintiff's favor, which is standard at this point. As with David and Obermeyer, the remaining plaintiffs were not engaged in any criminal activity, were not a danger to the officers or the public, and were not resisting. Indeed, some were attempting to leave the area when they were shot, but that does not equate to evading arrest because they were not under arrest and had not been asked to halt. The government interest is minimal and does not meet the strong threshold necessary to outweigh the intrusion on Fourth Amendment interests of intermediate force. Russell's argument under Graham fails. And yeah, it is very possible the courts may see this as something that shouldn't have happened. It's going to be a long time until we see where that ends up, though, because this case has been going on for almost a year and a half already, and we're still at the very earliest parts of this. Individual capacity defendants previously argued no case law clearly established the alleged Fourth Amendment violations, or that Russell should be held liable to them. That seems to not so much be the case. For decades, the law has been clearly established that warrantless arrest requires probable cause. Referencing back to 1981. Hey, that's when I was born. Another case from 2008. Another case from 1984. Supreme Court has cautioned that in the context of qualified immunity, officers will often find it difficult to know how the general standard of probable cause applies in the precise situation encountered, and thus existing precedent must place the lawfulness of the particular arrest beyond debate. Russell, however, does not argue that the federal officers had probable cause or that they are entitled to qualified immunity, because a reasonable officer in their position would have believed they had probable cause. We may see this come up later because there are a number of now named defendants in the case whose actual names are redacted currently. Further, the court finds, as alleged by Pettibone, that this is the rare obvious case where the unlawfulness of the conduct is sufficiently clear. When defendants conduct is so patently violative of the constitutional right that reasonable officials would know without guidance from the courts that the action was unconstitutional, closely analogous pre-existing case law is not required to show the law was clearly established. And based on decades of precedent, it was beyond debate that a person could not be taken off a city street, searched, and detained without a warrant or probable cause. That law enforcement may have purportedly seized Pettibone as part of an investigation into purported damage to federal property or a crime that purportedly took place on federal property is no different than any other criminal investigation. Federal law officers clearly knew in July 2020 that they may not lawfully detain persons without a warrant and without probable cause under the U.S. Constitution. Going on to talk about David Obermeyer. For purposes of Fourth Amendment, a seizure occurs when a law enforcement officer, by means of physical force or show of authority, in some way restrains the liberty of a citizen, and therefore they were seized within the meaning of the Fourth Amendment. They argue the law was not clearly established that federal law enforcement should not respond with general force to large protests when some people are engaging in violent acts. However, David and Obermeyer say they were specifically targeted for force when they questioned federal officers about their behavior related to other peaceful protesters. The law was clearly established that they had the right to criticize and verbally challenge the officers, referencing a 2015 case. And also referencing back to the Pucha case that we referenced earlier, that using profanity and criticizing police is not a crime. 1990 case, obscene gestures and yelling profanity as an officer was not illegal. Criticism of the police is not a crime. The law was clearly established in 2020 that use of batons and chemical irritants are intermediate levels of force that require strong governmental interest to be used. Such interest may include preventing a serious crime, responding to the risk of harm to the officers or the public, responding to a serious risk of flight, or responding to the suspect resisting arrest. None of those interests applied, as we went over before. A case is similar to Young, in which, as alleged, David Obermeyer was subject to baton strikes and chemical irritant without justification. Indeed, this case is more compelling than Young, where the injured party had committed a traffic offense and then refused to cooperate with law enforcement. And the Ninth Circuit held those minor offenses did not provide strong enough countervailing government interests for the force used without warning. Here, David Obermeyer allegedly did not commit any crime because criticizing and profanity is not illegal, so there was even less justification. And yet, in Young, they said that use of force, or the law against the use of force, was clearly established. The Headwaters 2 and Young, among other cases, provide explicit notice to any reasonable law enforcement officer that the use of force under the circumstances alleged by David Obermeyer was an unconstitutional use of force. This clear principle would have put a prudent officer on notice that two officers tackling, using pepper spray, and punching plaintiff in the face without first attempting a less violent means of arresting protest who was not, by her account, attempting to flee was a violation of the person's Fourth Amendment rights. This is another case here. It looks like Lalonde versus County of Riverside, where an officer should have known that using pepper spray after someone surrendered and was helpless was excessive force. Something we've seen used by Portland police before, where they've had someone arrested, then pulled down their face mask, which they can't reach to pull up because they're handcuffed, and pepper spray them and leave them in suffering agony. Remaining named plaintiffs, again, trying to say that they didn't have, that the law was not clearly established for general force. Individual capacity defendants cite an Eighth Circuit Court opinion to support this agreement. However, the Ninth Circuit instructs the appropriate responses for the government to ensure adequate police presence and to arrest those who actually engage in such conduct. Taking a slight step back here, normally when you're looking at circuit courts, they're the next step up from the district court, which Oregon has one district. And when you have, and within that district, they will generally focus first on precedents that have been set in that circuit, and then look to outside circuits if they need further guidance. So here, individual capacity defendants, Russell in this case, said, well, here's a thing from the Eighth Circuit that supports our view. The Ninth Circuit says, no, we've already said this is what we view as appropriate. They could theoretically appeal that, and it would go up to the Supreme Court because you have two circuit courts that are disagreeing with each other. And at that point, the Supreme Court would evaluate them. I don't know that that's going to happen in this case. Actually, since we're at the district court level, first it would get appealed to the circuit court, the Ninth Circuit, who would uphold the district court most likely because, you know, the Ninth Circuit's the one who already said this. Then it would go to the Supreme Court. Referencing the Ninth Circuit Court case Collins, it has been clearly established since time immemorial that city streets and sidewalks are public fora. Restrictions on First Amendment activities in public fora are subject to a particularly high degree of scrutiny. Collins involved protests took place in San Francisco after verdicts in the state criminal trial on the officers who beat Rodney King. Racial justice protests. Officers gave several dispersal orders. Large crowds of protesters remained after the dispersal orders, moving down the street, and objects were thrown at police. I feel after is going to be relevant here. Officers asserted the crowds were acting as an organized group, and the plaintiffs asserted the crowd acting as a diffuse body of individuals. Police encircled and arrested the group en masse. Yay, kettling. Ninth Circuit also addressed potential group activity in Lyle. The proposition that if a person is simply present in the vicinity of potential activity without doing anything else, the police do not have probable cause to search him. It does not, however, imply that the police can never possess reasonable suspicion or probable cause unless it is individualized. If a group of people is behaving as a unit and it's not possible for the police to tell who's armed and dangerous and who is not, the police can have reasonable suspicion as to members of the group. Yeah. This looks like it's going to fall flat on its face because the claims are already that these were people who were leaving the area. They were with small groups of peaceful protesters. There were no bad actors. There were no dispersal orders in place. So thus, as of 2020, the law was clearly established that law enforcement officers could not use physical force to seize an entire group of protesters unless the crowd was behaving as a unit and it was not possible to tell who was armed and dangerous and who was not. Based on the allegations, when these plaintiffs were shot, it was obvious they were not armed, not dangerous, not engaged in any violent or illegal behavior, nor was anyone around them engaged in such behavior. Those allegations are enough to preclude the argument that qualified immunity is warranted. Considering the force itself, Ninth Circuit has already resolved the issue. Every police officer should know that it is objectively unreasonable to shoot, even with lead shot wrapped in a cloth case, which would basically be a beanbag round. An unarmed man who has committed no serious offense, has been given no warning of the imminent use of such a significant degree of force, poses no risk of flight, and presents no objectively reasonable threat to the safety of the officer or other individuals. Yep. Yeah, beanbag would be intermediate on this case, because it's a less lethal force. It's just in the case that this is referencing, Delore, I guess the person got shot with a beanbag instead of, we're now, Portland Police tends to use the foam-tipped 40mm grenades. Now they go on to supervisor liability, because qualified immunity is unavailable for any of the direct acts by the federal officers. And the final analysis is whether the law was clearly established that defendant Russell could be held liable. Ninth Circuit treats supervisor liability under Code 1983 and Bivens interchangeably. Standards for supervisor liability: that a supervisor must be personally involved in the violation or have a sufficient causal link, have been clearly established well before 2020, referencing a case here in 1989. As discussed above, plaintiff's allegations, taken as true, meet this long-standing, clearly established standard. So since they established that under Bivens, we don't have to review it under qualified immunity. So now we go on to, and I'm going to really quick sidestep here, because now we're talking conspiracy charges. This is, again, the latest amended complaint that the plaintiffs have filed. This whole time we've been talking about the first claim of relief, which was violation of Fourth Amendment right, Bivens claim. Most of the plaintiffs, except for two organizations against Wolfe, Russell, and a slew of federal officers whose names are still redacted in their individual capacities. So we've only been focused on these two that apparently I'd have to process that scan to highlight. Anyway. Now we're looking at conspiracy claims, which here, seventh claim is a conspiracy to deprive rights. Let's see if the eighth claim is... the eighth claim then is going to be a failure to prevent a conspiracy to deprive rights. Hmm. 221. Oh, let me... I think you mean line 221. Let me... I gotta find that. Here we go. Now the names here, those are the plaintiffs. Those are the people that filed the lawsuit. The only names that are being redacted at this time are the officers who have been identified and named in this. Oh no, it's totally fine. And for the record, I did not do the redactions. These were done before they were uploaded into the court system. So either one of the lawyers did this or the court themselves did it. I pulled this down from Court Listener and then just looked at it to see what I was trying to figure out here. So yeah, so talking about no, we've seen that. We've seen times where redactions were just they changed the text to black, or the text background to black, but didn't actually cover anything. And yeah, there's been some pretty bad stuff. So anyway, yeah. So we're talking now conspiracy, saying that the magistrate judge failed to accept allegations that federal officers under Russell's command worked with officers of the Portland Police Bureau. Wolfe met with the union president, and that federal and Portland police officers worked together to infringe protesters' rights. The plaintiffs contend because the protesters were supporting BLM, and plaintiffs allege that federal and local police worked together to stop the protests, they worked together in a conspiracy driven by racial animus. Court agrees with Judge Yo that the inferences are a step too far for plaintiffs' claims under Code 1985 and 1986. At most, plaintiffs allege a conspiracy to disrupt and prevent First Amendment rights, and that both local and federal law enforcement showed animus to protesters. The missing link, however, is that the animus was racially motivated. Because they're treating it more as an ideology motivated rather than I don't like it, but I can see where Judge Simon came from, and part of me has to agree in a legal. He's basically saying they weren't targeted because that being BLM supporters was not enough because they weren't black, basically, or they weren't targeted because they were black. I have to clarify that because I know at least one, Mac Smith, is black. So, yeah, they targeted people based on ideology and not based on racial motivations, and that really don't like that, but I I'm gonna need a drink after this. So the last thing, final plaintiffs contend that they erred in not addressing a specific request for leave to amend, to add specific allegations to clarify the first claim to relief and elaborate on the Bivens special factors arguments. It's yeah. So the plaintiffs had asked for permission to resubmit the claim with more detailed information and apparently more facts based on a new report that DHS had released after the complaint, which would have supported the conspiracy claims. So Judge Simon refers to federal rules of civil procedure that if court should freely give leave to amend a pleading when justice so requires, and district court should apply the policy with extreme liberality. The purpose of the rule is to facilitate decision on the merits rather than on pleadings or technicalities. A district court, however, may, within its discretion, deny a motion to amend due to undue delay, bad faith, or dilatory motive on the part of the movant, which would be the plaintiff in this case, repeated failure to cure deficiencies by amendments previously allowed, undue prejudice to the opposing party by virtue of allowance of the amendment, and futility of the amendment. What I see them talking about here is the idea of getting a third bite at the apple. If you make a claim for relief and you say that this is what happened, and the judge comes back and says, "Oh, that's not enough of a reason," you can ask to amend your claim to give more information to support your position. But if you don't do it properly that second time, the judge may say, well, no, you're not going to get a third chance. A case that I've witnessed this happen was with Alan Swinney with his bail reductions. I didn't see his initial bail hearing, but I was there at one of his bail reduction hearings where his lawyer didn't come in with the evidence of finances or assets or anything to prove why the bail that was set was unconstitutionally high. So, months down the road, his new attorney tried to come in and do the same thing, and the judge smacked it down because they had already made their arguments, and they failed on the second attempt. No, you're not going to get to go at it a third time using the same logic. They say futility of amendment, however, can by itself justify the denial of a motion for leave to amend. When granting these factors, all inferences should be made in favor of granting the motion to amend. Chad Wolfe, he was the acting director of Department of Homeland Security in the later years of the Trump presidency. He was the one who was in charge of DHS when the George Floyd protests started, which caused him to be the one who was responsible for organizing the Diligent Valor operation, which sent a whole bunch of federal agents to Portland under the guise of protecting federal buildings. But yeah, there was a lot more. So yeah, Judge Simon goes on to talk about how leave to amend may be denied if the proposed amendment is futile or would be subject to immediate dismissal. Only if no set of facts can be proven under the amendment to the pleadings that would constitute a valid and sufficient claim or defense. Here, the concern with the plaintiff's request for leave to amend is not based on undue delay, bad faith, or dilatory motive, or repeated failures to cure deficiencies by amendments previously allowed. Instead, the court finds the proposed amendments futile. Regarding the policy-based allegations regarding Bivens' special factor analysis, the claim is necessarily bound to high-level decision. So Bivens would always fail in this case, and an amendment to the complaint wouldn't change that. As for the DHS report that was released after the current version of the complaint, the proposed amendments supposedly still lack sufficient detail to cure the deficiencies and would be futile for the same reasons that the current complaint fails to state such a claim. The court went ahead and looked at the DHS report here, said that the 6 new facts don't mention or concern Wolfe or Russell, so they're non-factors on trying to bring that in. Nor do the new facts include any evidence of an illegal agreement or conspiracy involving Wolfe or Russell. So at this time, court denies leave to amend the Bivens claim against Wolfe and plaintiff's conspiracy claims against Wolfe and Russell. The court, however, agrees with plaintiff that new facts may come to light in the future. If that happens, plaintiffs may seek leave to amend if appropriate. The court thus dismisses these claims without prejudice. Without prejudice just meaning they could be refiled again later. So then we finish off. The court adopts in part recommendations, grants in part the motion to dismiss filed by defendants Wolfe and Russell, and dismisses without prejudice the first claim as against Wolfe and the 7th and 8th claims as against Wolfe and Russell in their individual capacities. So again, we are back to Russell in his individual capacity is still on the hook for the first claim. All of these federal officers whose names are redacted are still on the hook in their individual capacities. The conspiracy, Wolfe and Russell are both pulled. Actually, are they trying to say... Yeah, the 7th and 8th claims are still only dismissed against Wolfe and Russell, so it appears that the unnamed officers are still potentially on the hook for working with Portland police to deny rights, and I believe that also... Yep, the same people in the 8th claim. This does not mean that any government agencies have weaseled their way out of anything. Like we said in the very beginning, and I know a lot of people weren't here for it then, but when there was a change in administration back in January, that changed the official parties. President Trump got replaced with President Biden. Chad Wolfe, as the head of DHS, got replaced with, I am blanking the name, which is why it is in here somewhere. Here we go. Oh, no, that is... Here we go. Sorry, so Chad Wolfe was replaced by Secretary Mayorkas. For the case, for the official capacity charges. But unless new evidence comes out that, emails from Wolfe to Chief Lavelle or something like that organizing more direct interactions between local law enforcement and the federal law enforcement, Wolfe is out of the case. Russell is still in the case because he's still being sued in his official capacity as the director of Region 10 for Federal Protective Services. All the unnamed federal officers are still on the hook. This was, a lot to go over, and I really apologize. I did not anticipate it taking almost 2 hours. But yeah, that's where we're looking at here. There is definitely... when you look on the docket, I mean, this started August of 2020, and we have had almost 150 filings in the year and a half since. But we are, slowly trudging through the pretrial motions and such, and hopefully, now that qualified immunity has been sorted out, we'll be able to start getting some, getting a little bit closer to getting some resolution on some of these things. It would definitely be nice to see, to see some progress being made towards holding some people accountable for these actions. I will go ahead and say it's not going to be enough. These are still systemic issues that can't be solved purely through the judiciary. The executive and legislative branches don't seem particularly interested in taking up these issues either. And maybe that's something we need to push people on more. I mean, there was a lot of good stuff that happened last year, and then that momentum kind of fizzled, and yeah, the story's getting old, and I'd really like to see a chapter where things don't go down the toilet. Yeah, I mean, some of these cases that were referenced, I'm like, I see 1981, it's like, hey, wait, that's the year I was born. My entire life, cops have known better, and they still do this stuff. That's people who were cops when I was born are retired now, and this whole thing is just incredibly frustrating. So yeah, definitely want to thank everyone for tuning in and joining in the conversation. A thanks here to the Legal Information Institute for some of the background here on Bivens cases, to Court Listener with the Recap Project. They're a great resource for cataloging all of these federal cases and filings, especially where federal courts like to charge excessive amounts for the documentation. Something that hopefully we'll be able to see change in the coming years as well. Definitely, if you feel that you know other people that might be interested in this, please feel free to share the video to them. Give us a like, comment in the comments below. I just ask you to keep the conversation relatively polite, because we know that this is going to be a hot topic. And if you want to support the work that we do have our link tree down in the video description, which has information on how to reach out and support us. But definitely you can get a lot more help from with sharing the video and getting more information. In the meantime, I'm going to go ahead and drop off, get that drink, let my voice recover, because I can feel the gravel coming in now. And y'all take care. Be safe. Hope you had a good holiday, and have a good New Year.